I've got about 30 minutes with you, and so my job is to get you on fire for the rest of this conference. So if you can work with me to help you, that would be extraordinary. And very often when I do that, I get myself on fire as well. I wanted to say thank you to the conference for inviting me. This is a very honored role for myself and for the organization that has worked with so many of you over the years in so many different ways. Thanks very much, Mike, for thinking of me as someone to address this group. I'm sorry that Almudena wasn't able to be with us today because she has, at least in this keynote context, and we'll hopefully hear from her later on, but I know that she sends her deep sadness and regret for not being able to be here. It was entirely not her fault because you can blame it on the gods and on the airlines. But as we saw when, just when Mike was mentioning her name, that she managed to call him. That in human rights work, timing is everything. So that's how you know that Almudena is one of the most successful and extraordinary human rights lawyers that we have. So I wanted to start out today to talk about the following thing. If the military in some unnamed country rounded up men based on their race, rounded up women based on their race, held them in secret detention, beat them, and then deported them out of the country, we would all say that that is a human rights violation. We would be outraged, we would be activating our networks, we would be figuring out what we could do, we would be trying to learn more. If the national police in some other country spied on mosques, and a religious minority in the country decided to spy on mosques to be able to determine what people were thinking, to invade the community, the Muslim community that's happening there, we would say that's a human rights violation. We would be outraged, we would be writing letters, we would be sending petitions. If a paramilitary organization in some country just randomly set up checkpoints, not to arrest people that had committed crimes, but just to harass an entire community, to keep them on the back foot, to keep them from moving forward, we would say that is a human rights violation. All of us. All three of those things are happening in this country right now. And it's not a paramilitary group, and it's not the national police, depending on how you characterize it, but it is happening through law enforcement, it is happening through the CIA, it is happening through the FBI, it's happening through local police. Three things I want to talk with you about today that brings this home are the cases that CCR has been doing here: Turkman versus Ashcroft, Hassan versus the City of New York, and Floyd versus the City of New York. Now, before I start this presentation, there are two twin goals in every single human rights endeavor, whether you're doing it as a lawyer, whether you're doing it as an activist, as an organizer, as a civilian, as a community group. Two twin goals. Number one is transparency. Number two is accountability. But when you're doing those two things, you end up fighting the two pieces that the state or the corporation that is committing these human rights violations, there are two things that they can do to not only counteract your efforts, but to make your efforts virtually impossible, to make people feel like, what can we possibly do? And those two things are secrecy and impunity. So when we're talking about exposing the cover-ups, right, we're talking about exposing two pieces. Number one, what is the secret thing that we don't know about as a society that is happening that we need to stop? Number two, what are the mechanisms by which the people that are doing those bad things are completely not being held accountable? Not only in terms of their actions, but in terms of even the structures and mechanisms that we normally hold for people to be, and entities to be held accountable. You know, one way of looking at it is, if I did that thing, I know that I would be under the jail. But if they're doing that thing, why are we having a discussion about things like immunity, qualified immunity, things like the perpetuation of violence, about terrorism, about those national security questions? Why are we having that discussion when we know that these folks are doing these things? At CCR, and thank you, Mike, we are 50 years old this year. For those of you of a certain age, you might remember the other CCR, which is the Creedence Clearwater Revival. that CCR. It's only 49 this year, so we have them beat by a year. But at CCR, we have something that it's a kind of a thing that we go by, which is that if you have an activist, a lawyer, and a storyteller, you can change the world. Those three things, activist, storyteller, lawyer, you can change the world. And why is that? Because again, what we're trying to do is we're trying to unearth what's actually happening. So in terms of transparency, you need activists, because activists are connected to the people who are on the ground, who are being who are subject to these human rights problems. And the people themselves become activists in their own liberation. So activists are a key tool. That's how we first know how things are happening. Another way that we first know that things are happening is through storytellers, through people that pass stories down within their own communities throughout the generations, people who are journalists, people who are artists, people who are telling stories about what's actually happening. Those stories have the ability to not just influence us as people that are looking to expose cover-ups and to find accountability, but they have the power to transform society. In fact, communication in that way, storytelling, is by definition, in my view, societal transformation. You can't be unchanged. You can't unhear a story after you've heard it. And the stories that we're going to be hearing today are going to be so powerful, none of us will be able to unhear it. And all of us will be then asking ourselves, what are we going to do about it? Which brings us to the lawyers. Lawyers are a very important tool in social change, but lawyers are not the most important tool in social change. The law is a blunt instrument. In fact, and it's not necessarily pitched to get to the broadest human rights problems as experienced by the individual. But if you do it in a particular way, particularly if you align yourselves with partnering with the people that are the most oppressed, taking your leadership from them as opposed to asking them to take their leadership from you, you can transform the law and the doing of the law to a very useful, powerful tool. For example, if all of us decided that we wanted to go to Standing Rock today, we were going to get on the planes were working. We'll see how that works. The weather's much, much better in Standing Rock than it is here right now. We all decided we were going to get on the plane, and we were going to go as lawyers, and we were going to go as activists, and we were going to go as storytellers. The thing that we would not do is we would not be sitting here right now figuring out what our legal strategy is, would we? No. We would wait till we got on the ground in Standing Rock, and we would ask people, what's going on? What are the problems? What is happening that I'm not hearing about, and what help do you need? And that's the key to movement-based, community-based lawyering, the lawyering that you're going to hear about at this conference, and the lawyering that I'm very proud that CCR is doing. And it's on the basis of that lawyering that we entered into 3 cases, Hassan, Turkmen, and Floyd. I'm going to talk briefly about Hassan and Turkmen, but I'm going to talk a little bit longer about Floyd. Turkmen versus Ashcroft, right after 9/11. Before I get into this, each one of these cases that I'm going to be talking about stem from domestic abuses by our government and by local and national law enforcement that came from the 9/11 phenomenon. So while the rest of the world thinks about 9/11, and as I do as well, as one of the great horrible tragedies in modern times, those of us that are in the human rights field recognize that it is also has unleashed one of the gravest human rights crises of modern time in the US. Turkmen versus Ashcroft, right after 9/11, the buildings were down. I was still in New York. It was horrific, but it was more horrific for some people than it was for me. I was thinking about my kids. I was thinking about how I was going to get to work. I was thinking about what life was going to be like. Was it going to happen again? But men in New York City started disappearing. I didn't know it at the time, but men who were Arab, who were Muslim, some of them were neither Arab nor Muslim, but could have been connected to Arab or Muslim communities, they started disappearing off the streets. And how we knew this was that people in those communities were contacting the Center for Constitutional Rights because they had known that we had filed the first challenges to the men in Guantanamo. They knew that we weren't afraid to take on the US government. They had no connection to CCR, but they contacted us and they said, can you help me find my brother? Can you help me find my father? it was odd for us because in the midst of all of that crisis, one of the things that we were not thinking would be that men would be disappearing. So we began to look into it, and we heard more stories and more stories and more stories. We found out that what was happening is that the Attorney General, who at the time was John Ashcroft, and the FBI, and the FBI chief was Robert Mueller at the time, had created a program where they were sweeping up Arab and Muslim men off of the streets of New York and putting them into federal detention. And they were doing this under the plenary immigration power that the United States government has. It wasn't a criminal investigation. It wasn't pitched as a terrorism investigation. It was pitched as an immigration sweep. The US government has the power to detain people who are out of status. They can put them in immigration detention if you are undocumented. That can happen. But they were using that as a tool, as a leverage point to get to a much deeper piece. And the deeper piece was they actually were harassing the entire Muslim and Arab population in New York, trying to find links to terrorism. I have news for you. Even though the US government can put people in immigration detention for being out of status, they cannot do it based upon religious profiling, based upon racial profiling, and based upon a mistaken, ultimately mistaken belief that anybody that happens to be out of status and Muslim or Sikh or Arab must have some information to be able to give the US government. And rather than asking them, they just took them. So that was our first case. The reason why I'm talking about it is that case was filed shortly after 9/11, and it is still going on today. Here we are, 13 or 14 years later, that case is still going on. And why? The government has already conceded that they shouldn't do this. They've already stopped doing this. And so at some level, the transparency piece through the litigation has come out. We know what they did. We know what they said that they did. We have our clients and the people that were talking about it saying this is what happened. But the accountability piece. They said it was wrong. We're sorry, we'll never do it again. You heard that one before? And so now the question is, who's going to be held accountable? I'm very proud to say that CCR, rather than just thinking about it as a racial profiling case, saw this as an opportunity to name high-level Bush officials, including the Attorney General and the former head of the FBI, as defendants in this case. And so this entire case now is not about what happened. This entire case is about who's responsible and what are we going to do about it. I'm very happy to say that just earlier this week, the Supreme Court accepted certiorari in the case, and so we will be arguing Turkman versus Ashcroft in the Supreme Court this year. Thank you. Yeah, y'all are looking a little less soggy now. How are we feeling? We ready for some more? All right, let me tell you about this story. Hassan versus City of New York. Hassan versus City of New York is a case in which, now I want you to pay attention to this because there's geography involved, where the New York City Police Department has been spying on mosques and Muslim communities in New Jersey. One more time. The New York City Police Department is spying on mosques in New Jersey. Now, they were also spying on mosques in New York and Connecticut. And those of you of reasonable mind and goodwill might ask yourself, how on earth could the New York City Police Department possibly have any jurisdiction to spy on people in another state, leaving aside the fact that they shouldn't be spying on anybody even in their own state, even their own city? Well, it's a good thing that you asked that question because that's what we asked as well. And the New York City Police Department said the following thing. First of all, they said, we're actually not spying on the Muslim community. What we're doing is we're gathering information and intelligence about potential terrorists. So let me take a step back. Remember, transparency and accountability, exposing the cover-ups. That's what we're talking about today. Do you know how we found out about this whole program. Now, our police commissioner at the time, who I will be talking about more later in the stop and frisk case, was not the most transparent person. He didn't say, this is what we're doing. The mayor didn't say it, the governor didn't say it, the president didn't say it, the joint task force didn't say it. No one said we're spying on these communities. And the way that we found out about it was through the Associated Press. Remember when I talked about activists, lawyers, and storytellers? In this story, the Associated Press is the storytellers. They did a Pulitzer Prize-winning report on the massive program of spying by the New York City Police Department in places in New Jersey. And because of that information, because that was exposed, we then were able to file our lawsuit with our partners, Muslim advocates. Getting back to the case, lawyers in the room will appreciate this. So we filed our litigation. We made all of these broad allegations. Interestingly enough, in the community context, this is sort of a community organizing pro tip. In the community context, we were fortunate enough not to make the mistake that a lot of people make with respect to how they characterize the Muslim community. The Muslim community is a multiracial community. The Muslim community is a multi-ethnic community. People come from different parts of the globe, all of which is beautifully arrayed in the state of New Jersey. So in our plaintiffs class, the people who were challenging this program, we had organizers and community groups and mosques from Newark, New Jersey, and these were African-American Muslims. We had organizers and girls' schools and Muslim associations in central New Jersey, including the Muslim Students Association at Rutgers University, including people who were Pakistani, and a broad range of groups. Interestingly enough, we're able to come together around this particular piece, the spying piece, and to be able to build relationships between each other that had been harder to do before there was a common cause. So here's what the lawyers will appreciate. We filed the lawsuit. Of course, the city of New York moved to dismiss, and they said, we're actually not doing anything that's illegal. This is not religious profiling. It sort of is a syllogism. It goes like this: since terrorist attacks are done predominantly by Muslims, and there are Muslim communities that are here, therefore it is okay for us to be able to look to the Muslim communities to find information about the terrorists. For some people, that made perfect sense. To the rest of us, that was one of the most racist, vile things that any government could ever try to use as a justification, much less in court. So when they made that statement in court, they moved to dismiss our case. We fought back. The judge in the lower court, this is one of the largest human rights cases and civil rights cases affecting Muslim folks today in the United States. The judge issued a 10-page opinion. For those of you that are not used to that, a 10-page opinion is tiny for a massive case like this. They usually they can run 30, 40, 50, 60 pages of thought, of rationale, of justification. And we got 10 pages from this judge. And the judge essentially said, the plaintiffs think they have a problem with the New York City Police Department, but that's actually not the problem that the plaintiffs have. The problem that the plaintiffs have is that the Associated Press were the ones that let them know what was happening. I've read it 4 times. I'm not kidding. So essentially they were saying that the problem is not the program. The problem is that you know about it. That's what they were saying. That's what our judge was saying. So again, trials and tribulations, challenges of doing this kind of human rights law. We then we appealed that terrible 10-page decision to the higher court, the Court of Appeals in the Third Circuit of New York, in New Jersey, and we got a very different result from the Third Circuit. One of the things that we did was we were trying to pitch this as in the broadest sense that we could, not as a small, the New York City Police Department is trying to keep us safe, but to look at this in the arc of history, that this is a Muslim religious freedom profiling case that we have seen before. We've seen the government do this before, and we were very fortunate to have a panel in the Third Circuit Court of Appeals that issued a wide-ranging, beautiful, multi-page opinion talking about why this is one of the key issues of our time. And in it, we included an amicus brief, which is a friend of the court brief from Karen Korematsu, from the Korematsu family, and from people that had been in Japanese internment camps, which prompted the court to say the following things. We have seen this before. We've seen it with African Americans during civil rights. We've seen it with communists during the Palmer raids. We've seen this with Japanese Americans during internment in World War II. Why is it that we can see so clearly with hindsight what we can't see with foresight? Meaning essentially that we repeat this all the time, but we create different terrorism and fear rationales to be able to do it, and generations of people forget. Well, I'm here to tell you that we are in this conference, we are in the generation that not only cannot forget, but we're in the generation that is really charged with doing something about it. Which brings me to Floyd versus City of New York. This is the stop and frisk lawsuit that Center for Constitutional Rights won in 2013. I want to say this, that case started in 1999. Most people don't know it. It started in 1999. There was a man, any Bruce Springsteen fans out there? Bruce Springsteen? Yeah, Bruce. There was a man named Amadou Diallo in New York. He was an immigrant from Africa. And he was in the vestibule of his building up in the Bronx, standing outside, right outside of his building in the Bronx. It was a cold night. The police had a unit called the Street Crimes Unit, undercover, complete cowboys, completely unaccountable to everybody. They just ran around and they just beat people up, they arrested people, all kinds of terrible stuff. Well, they come across Amadou Diallo. Amadou Diallo standing in the vestibule of his hallway. They say something to him. He turns and looks at them. These guys think he's up to something. They have no information about what he might have done. They said they were looking for a rape suspect. And Amadou Diallo, in 1999, did both the worst thing that you can possibly do to a police officer and simultaneously the thing that makes the most sense to do when you're an undocumented person. You know what he did? He reached in his pocket to pull out his wallet because he assumed that they wanted his identification. And for that act, which I just did, being a black man on the streets of the Bronx in front of your own house, he was shot 41 times. If you've heard the Bruce Springsteen song 41 Shots, it's about the killing of Amadou Diallo. And this happened in New York City during a time of great consternation and great uprising around the question of policing, very much like the one that we're seeing today. And the organizers in New York City who had been organizing against police brutality, against police misconduct, against the killing of unarmed black people in 1999 came to the Center for Constitutional Rights and said, let's partner on this. You have to figure out a case to be able to end the Street Crimes Unit. So we filed the first case, which was called Daniels versus City of New York. We filed that case. We actually won that case. We got a settlement in 2002 where the city said, you're right. They disbanded the Street Crimes Unit. They said, we're sorry. We're going to issue an anti-racial profiling policy. We will never, ever, ever do it again. Now, that was in 2002. Linking this to the other story, we know what happened on September 11th, 2001, and one might think policing in New York and the World Trade Centers coming down are two different things, but they were linked very clearly. Even as the New York City Police Department was telling us in that case that they were done doing racial profiling, they were getting resources and funds from the US government to be able to tackle the question of terrorism. And of course, in all of these situations, they were not finding any terrorists, but they thought it was a great idea to invest more deeply in the New York City Police Department around investigative techniques. And one of the investigative techniques that they were investing in was stop and frisk. And so between 2002 and 2011, stop and frisk didn't go down with their promise. Stop and frisk went up 600%. 600%. So we filed another lawsuit in 2008, and that's the case that we won after a 9.5-week trial. 5 million people were stopped on the city streets of New York. There was a 14th Amendment claim, which meant that they were doing it in a racially discriminatory manner. There was a 4th Amendment claim, which was saying that they were doing it for no particular reason. We won both of those cases, a 200-word opinion from the district court at that time, talking about how this practice was completely unconstitutional. And why does that matter today? Matters today for a couple of reasons. I don't know if you guys have been watching the presidential discussion. But I have to say at this point that Center for Constitutional Rights is a 501c3 organization, and our tax status does not allow us to be in favor of or against any particular candidate. I'm just saying. But you might have heard that there's a call to bring stop and frisk back. But not just in New York, and nationally. And then there was this discussion about how stop and frisk actually worked in New York City. Now, it didn't work. That was the other piece of this. Not only was it illegal, not only was it unconstitutional, not only did it criminalize entire communities, and I want to be clear, for those of you that don't know, when we're talking about stop and frisk, this is not just a, excuse me, ma'am, may I pat you down, excuse me, sir, can you tell me where you're going? These are aggressive stops that demoralize and criminalize people all the time. And so the way that it's experienced on the ground, even with me and my kids, is that there's a tremendous amount of fear and anger that happens when you walk down the street, because you know that the person that you have to fear the most out of everybody that you're going to meet, including the drug dealer, including the gangbanger, is the cop that might haul off and do something to you. That's how stop and frisk really works. So for people to call for stop and frisk coming back at this point, I think speaks to another issue that we're going to be dealing with at this conference, which is the question of power. And what I mean by that is you file cases, you do campaigns, you get concessions if you're lucky, you get transparency, they say this is what's happening, you might even get accountability. We will never do this again, this person's going to jail. But the thing that we know, if you've been around long enough, is that that power that does the human rights abuse to begin with, that creates that secrecy that shields the transparency, that creates the impunity that shields the accountability, that power never goes away. And it begins to manifest itself in different forms. And so none of us should feel like the job is ever done. None of us should feel that the work that we're doing on one particular issue is not linked to this other work that's happening over here, because it is actually power. It is oppressive power that we are fighting. But we shouldn't be confused between the manifestation of power in our case and the power that we're actually fighting. I say to people, we've CCR'd sued just about every president going back to 1966, actually going back to 1971. We've sued 16 attorney generals. We just sue everybody. And people say to me, well, you know, Barack Obama, man, is not George Bush. And I'm like, no, Barack Obama is not George Bush. But we're not fighting the president, we are fighting the presidency. And how do we know why that's important? Because Barack Obama, despite issuing an order to close Guantanamo the second day of office, do you know what was happening? I'm going to expose this cover-up. He was on television speaking big things, warming my heart, making me feel like justice was possible at the same time that his Justice Department was fighting all of the cases that we had in the pipeline from the Bush administration and fighting them with the exact same argument. President says we need to be better than this, we need to look forward and not back. Justice Department says this case needs to be dismissed because the power of the president will be impeded if we allow the Guantanamo detainees to be released, if we allow people to sue over their torture, if we allow people to even challenge the nature of their detention in Guantanamo. That's what was happening. So, for all of us, when we're thinking about policing, when we're thinking about mass incarceration, when we're thinking about immigration, we shouldn't be thinking just about issues. We should be thinking, what are the power structures that we are trying to dismantle through our work? That's the essence of what human rights work really is. That's where the cover-ups happen. That's how the cover-ups get exposed. That's how we begin to shift things from secrecy to transparency, shift things from impunity to accountability. One more thing I want to say about this is really it's about community and activists. I'm a lawyer. Been a lawyer for a long time. I love being a lawyer, but what I love more than hanging out with lawyers is I love hanging out with organizers. Why do I like hanging out with organizers and activists? They see the world very differently than we do. Lawyers see things in boxes. And it's good that we see things, we can't help it. You know, for the people that are here, you know, UW, you get trained, you got the boxes. This fits here, this one doesn't fit here. But activists, people who are people who are the most impacted by the abuse are the ones that get us to think outside the boxes. Because in law school, you're trained to say, here's the issue, here's the result. And then when you litigate the cases, very often courts will say, yes, that's a really big issue, and yes, that's the result that should happen, but there's nothing really here that the court can do for you. Because the government has immunity, because this actually, in a US court, this actually deals with foreign policy issues. There are a lot of reasons, a lot of boxes that the court can create that hurt you. But organizers and people that are connected don't see those boxes, and they will ask you the question, this is what happened to me, what can we do about it? They ask that all the time, and it's the biggest challenge for a lawyer. It's easy if you're litigating Enron. It's really, really hard if you have people whose families have disappeared, and there's no mechanism in the national context for them to be able to. They've tried everything, and they're coming to you because they've tried everything, and it's your job to answer that question. What can we do? And sometimes you just have to try the best thing that you can think of. And some of the greatest human rights achievements have not been these long, big, structured, strategic plans. They have been people coming together, trying and innovating. Maybe we'll try this. And the legal establishment will say, you know, that's really dangerous because we deal with precedent. So what if you try something and you lose and it makes it really bad for other people? That's how the legal program thinks. That's legitimate. But the other question is, what if you don't try and people are still suffering? They never answer that question in court. It's about risk. We are about taking risk. If you think about risks in a different way, you'll be more likely to take them. There has not been an enslaved person anywhere in the world that has escaped from slavery without risk. The definition of moving yourself out and liberating yourself from a structure is by taking risks. There is not a person undocumented that has come into the United States without some measure of risk. And so who are we as a legal establishment to say that risk minimization is part of the strategy that we're going to be using for liberation? It makes no sense whatsoever. No sense at all. So when I went to Ferguson in 2000, and just a couple of weeks after Mike Brown was killed, that I met some extraordinary organizers and activists, national folks that were on the ground, and CCR just went. We just went and we asked 6 weeks, what should we be doing? And we actually, from the organizers, created a whole legal defense structure for Ferguson because they needed to get people out of jail. That was their number one thing. So we helped do that. But here's what I learned from the organizers in Ferguson, and particularly I want to give a great shout out. If you have not looked at it, if you have not seen it, I know all of you have heard about it, but if you have not actually read the Vision for Black Lives by the Movement for Black Lives platform, you must do it, and you must do it today, because it is a vision for Black lives such that I have not seen. It is actually a blueprint for what the next generation of human rights work looks like in this country. It is done all by Black people. It is done all by organizers, and it is an extraordinary piece. And so here's the piece that I got from the Vision for Black Lives and from people. One of the pieces that they talk about, which I personally think is going to be the domestic human rights strategy moving forward, is this concept of invest, divest. What I mean by that, what they mean by that, is if you think about from the work that you do, where are you, if you're successful in making the change that you want, the question is, where do the resources go? Do the resources go to the communities that you're representing? Do they go to the communities that you care about? Do they go to the communities that you're from? Or do those resources begin to go into the organizations that are oppressing your communities? And so there's an interesting example about that. Y'all heard about police body cameras? Police, it's the cameras that the police officers put on. Here's the interesting thing about police body cameras. It is a policy solution that many people think is a great idea and agree upon. But here's how that plays down. The civil libertarians are the ones that say, we're really nervous about this because video is basically data. So if police have the data, how do we get it? How do we know who they're spying on? How do we know what they're doing with it? And that's an important thing. But the civil rights organizations and communities sometimes think it's a great idea. They say, you know, body cameras are great for two reasons. Number one, we can catch the cops when they do really bad things. And number two, it'll deter them from doing bad things because they know that we're going to catch them. But here's the thing. You know who else thinks it's a great idea? The police department. This is what the police department says. There was a study in Santa Clara. There are two main reasons why the police departments think body cameras are a good idea. Number one is that it allows the police to deter community members from doing bad things to police officers. And number two, it vindicate the police officers to show that they have not actually done something wrong. So now you have two groups that are on opposite sides. They have differing views of a particular solution, but we're moving forward that solution. But there's another piece that's really important here, and this is where the invest-divest comes in. Police body cameras are really expensive. We kind of think about them as these solutions, and you kind of get them like you get an iPhone. These are millions and millions of dollars. And there are police departments right now that are getting their counties to issue bonds so that multi-year payments so that they can pay for police body cameras. And if you, like me, are a person that believes that budgets are an expression of our values, right? What does it mean to increase the budget for police departments so that they can get body cameras? Shouldn't we be shifting those resources, our resources, into the communities that the police are supposed to be protecting? There's one more piece to this story which is key, and that is there are two companies in the United States that make police body cameras. One of them I can't remember, but the other one I think you've heard of. It's called the Taser Company. Y'all heard of the Taser Company before? So Taser, their brand is we create non-lethal methods of policing, right? But when President Obama announced in his 21st century on policing that police body cameras were a good solution that we should do, the stock for body cameras in those two companies shot up 400, 500%. So I would leave you with this question that I've learned from the Black Lives Matter movement and that I think is really important for us. If we think about body cameras as a solution, essentially what we are doing is that we are paying our government to pay a corporation to give tools to the police department so they won't kill us. Think about that. Think about that. So, what is, I think, the most important? I want to leave us with this piece here, is that human rights work is very, very complicated, and one of the main goals of human rights work, of course, is to do good. The other one is to not do any harm, and that we have to be conscious of connecting with the people that are the most impacted as we do this work, because we don't want to make that mistake of declaring mission accomplished on a policy objective that is actually further decimating our communities. And this happens all the time. When we're in a situation where you have to settle a case, if we're doing peace accords, if we're negotiating particular groups' rights to land, in the negotiation is always where things can fall apart. And so as we're doing that, we have to be strong. We have to keep our eye focused on the question of accountability in two ways. Number one, make sure that the bad guys go to jail for the bad things that they do, but the solution has to be accountable to the community. It has to solve the problem that community members came to you with in the first place. Thank you all very much. Appreciate it.